Password content case item 27. The look is 568 of 2014.
Yes. So far, no document part is concerned, but it is I can derive from the one decision 1986 volume 3 SCC 229 para 10 that has not been mentioned in the written notes. So far the other judgments are concerned, I have already relied below and I have provided the copies. In the case of Rup Singh Negi,
That Rup Singh Negi's judgment we have considered in one judgment.
that is not in para 10, 17 and 18. Now here it is a case, admittedly no evidence has been examined by them. No witness has been produced.
Need not.
And secondly, Lord, another case note 2010 volume 2 SCR 326, that is Saroj Kumar Sinha.
See, if the documents have not been provided to you, that is
Then
sufficient for a
yes,
matter of demand.
that is
So we don't need to go any
no
further.
need to go. Yes.
What do you say?
Lordship, on the point of documents, Lordship, I only want to say, Lordship, kindly allow me to place Annexure 2, Lordship. Annexure 1 is the charge sheet. Annexure 2 is the application of the petitioner by which the documents has been solved for.
Yes.
Thereafter, Lordship, by Annexure 3, they have given a detailed reply to the charge sheet, memo of charge, Lordship. In which, Lordship, they have not questioned regarding the supply of document in Annexure 3.
That is Annexure 4.
Annexure 3, Lordship, it is उपरोक्त कथित आरोप के विरुद्ध दिनेश्वर तिवारी की ओर से प्रत्युत्तर इस प्रकार है. Annexure 3, Lordship, page 58.
You come to Annexure 4.
And
In the second show cause also they have raised a grievance.
Yes.
But you have not furnished the documents.
In the second so called, Lordship, at page number 65, they have mentioned that in reply there to detailed explanation were provided by me by later date so. A request was also made by me to provide legible copies of the documents which was never provided to me in order to provide difference in regard to the same. Some copies were provided which were so faint that the same were illegible and as such no difference in regard to those could be given.
Page 67 also I have categorically stated. With regard to the next allegation, grade 2, stones were not used, such and such, that the inquiry was done in a hottest after a lapse of 2 years, not allowing, showing the conclusive evidence, not the copies even forwarded. This point has also been raised in Annexure 4.
And second, Lordship, so far the punishment order is concerned, Lordship, there are provisions for departmental appeal which I know.
You have a remedy of appeal also.
Lord, that is not, since it was violative of principle of natural justice, and we have also Annexure 6 is my against the interim in order of punishment. Annexure 6, page 73. There is no finding even by the inquiry officer. But to tell about the charge group, there is no finding at all, which I have just referred from Annexure A itself, page 18.
You have not provided in the documents.
Yes, that is the main.
Last I was having 2.% better.
You don't have any proof, nothing. What have you provided? He is also saying that some documents were absolutely illegible. So, as per B. Karunakar's judgment, it will start from the same stage.
Same issue.
Right? You provide him the documents and then you proceed, and he will be reinstated only for the purposes of conducting the departmental
Yes.
proceedings and no more. It's
Yes.
not that you must have attained the age of superannuation by now. Have you?
So,
Reinstatement nahi hoga.
No,
Reinstatement only for
to
the
that
purposes of
extent only,
department.
so that I can participate.
That's it.
Yes.
That should be sufficient. क्रिमिनल केस में क्या कर रहे हैं आप? मनरेगा का क्रिमिनल केस झारखंड में ऐसे ही चलते रहता है. Yes? What are you doing in the criminal case?
उसमें बेल लिया है, अभी भी चार्ज फिर नहीं.
कुछ नहीं होगा उसमें.
बेल लेकर 3 साल से जा रहे हैं.
Yes. Why? Why do you file criminal cases?
उसको पता करें.
क्या पता कर?
That is pending.
कौन सा केस नंबर है बताइए?
लातेहार यस केस नंबर 112/2010. I was just
112 of 2010.
2010.
Pending.
जो ऑनलाइन हम चेक कर पाए उसके हिसाब से ये लग रहा है कि अभी पुलिस के द्वारा चार्जशीट नहीं जमा की।
चार्जशीटें नहीं जमा हुआ
नहीं किए ना,
विकम सबमिशन
हम ऑनलाइन जो हमको पता
That
चला,
is a
कोई
fact,
इंस्ट्रक्शन
that is a
नहीं।
fact.
यही होगा ही।
बेल ले चुके हैं हुजूर, हम हाजिर हैं, लेकिन
तो हाजिर रहेंगे जब तक रिटायर नहीं हो जाए, जब तक मर नहीं जाए तब तक वो हाजिर रहेंगे और आपका केस खत्म नहीं होगा। यही तो कहानी है झारखंड का। जब केस प्रोसीड नहीं कर सकता है तो क्यों ही केस करता है? He has already taken bail, तो चार्जशीट इनके अगेंस्ट में होना चाहिए था ना,
नहीं हुआ।
वो भी नहीं करेंगे आप। बताइए।
अगर हम एब्सकॉन्डर होते तो अलग बात।
बाइदर क्लोजर का चार्जशीट
कुछ तो होना था ना, फिर
डॉक्यूमेंट पर हुजूर जो
जो एब्सकॉन्डर है वो एब्सकॉन्डर है। और कौन ही, सारे तो सरकारी लोग हैं, तो कहाँ से कोई एब्सकॉन्डर हो जाएगा? सैलरी देते हैं, पेंशन देते हैं। यस,
डॉक्यूमेंट
यू
पर
आर हैप्पी विद दिस? 2010, हाउ मेनी इयर्स हैव पास्ड?
15
सॉरी, 15 इयर्स। ये तो अच्छे लोग हैं जो कॉम्पनसेशन नहीं आप लोग से मांगते हैं, इतना हैरेसमेंट करते हैं आप। Why should they not ask compensation from you for harassing them for 15 years and not even submitting the charge sheet? होना चाहिए ना, वो तो ये है नहीं इसमें।
judgment in relation to document.
Yes.
Supreme Court. Para 10. And that has been followed by the Sound Court in another judgment. I have appeared on behalf of the petition. Para 10 will be better. This has been relied by the Sound Court in para 21. The judgment I have provided was just as
WPS number 568 of 2014. This writ petition has been filed for the following relief.
May I take your lordship's leave?
Yes.
Why?
The learned counsel for the appellant, the petitioner, has submitted that the petitioner was subjected to departmental proceedings for which charge sheet in Prapatra K was issued by the respondents on 29/4/2011. Pursuant thereto, the petitioner filed, along with the charge sheet, a number of documents were shown to have been enclosed. Pursuant to the charge sheet, the petitioner filed Annexure 2, इसका डेट नहीं है, mentioning therein that the documents that many of the documents enclosed, shown to have been enclosed, along with the charge sheet were not provided to him. In spite of such representation, the required documents were either not provided or some of them which were provided were illegal. The learned counsel submits that ultimately he filed his show cause without the documents and was found guilty. He has referred to the so-called inquiry report which has been annexed. यही है आपका इनका inquiry report, annexed date page 23.
Yes, boss.
So-called inquiry report annexed along with the counter affidavit, whereby again a number of documents were referred to, and it was stated therein that the petitioner has not been able to give any evidence in his defense. The learned counsel submits that against the said show cause, said inquiry report, a second show cause was issued and he responded to the same and again raised a grievance that the documents were not supplied or whatever was supplied was illegal. He submits that ultimately the order of punishment was passed as contained in Annexure 5, whereby the petitioner has been dismissed from service. He has submitted that the aforesaid aspect of the matter regarding non-supply of document has also not been considered. The learned counsel has submitted that certain documents were enclosed, were said to be the part of the charge memo, and in the final report also the documents were referred to, and therefore the petitioner has been highly prejudiced on account of non-supply of the documents, because of which he has not been able to defend himself. The learned counsel has relied upon the judgment passed by Honorable Supreme Court in the case reported in bracket 1986 bracket close 3 SCC 229 para 10 to submit that it has been held that when a government servant is facing disciplinary proceeding, he is entitled to a reasonable opportunity to meet his charges in an effective manner, and unless the copies of the relevant documents slash statements is provided to him, which may be used against him, the delinquent cannot be said to have been granted sufficient opportunity to defend himself. The learned counsel submits that under such circumstances, the order of punishment be set aside. The learned counsel, appearing on behalf of the respondents, has submitted that while filing his show cause reply, no such grievance was raised, and in his second show cause reply, the petitioner has stated that some documents were provided but they were not legible. He has also referred to the entire proceeding sheet of the departmental proceeding as contained in Annexure A to the contract affidavit, and has submitted that on filing of the petition for filing of the letter seeking the documents is not in dispute, and ultimately when the petitioner it was found that the petitioner did not produce any evidence in support of his defense. The inquiry report was prepared on the basis of the documents. The learned counsel has further submitted that even if this court finds that there has been violation of natural justice in the matter of supply of documents to the petitioner, the matter is required to be remitted back for taking it up from the stage of supply of documents, as the charge sheet is already there on it. That's it. After hearing the learned counsel appearing on behalf of the parties, this court finds that the charge sheet itself referred to a number of documents, and there was enclosure of large number of documents. There were number of documents enclosed to the charge sheet. The petitioner had raised a grievance that many of the documents enclosed therewith were not served upon the petitioner along with the charge sheet.
Page number 54.
Sorry.
Page number 54. Please.
Yes, 54. Yes, yes. Along with the charge sheet. And nothing has been brought on record from the side of the respondents that the said documents were duly served upon the petitioner pursuant to the letter filed by the petitioner as contained in Annexure 2. However, this court finds that the petitioner had filed his show cause reply and the proceeding sheet which has been annexed along with the counter affidavit it appears that on 23/12/2011, the petitioner had appeared and had demanded certain documents, and the case was directed to be taken up on 28/12/2011. And thereafter, it appears that the inquiry officer was changed. Change हो गया ना?
Yes.
And the entire order sheet does not reflect supply of the documents to the petitioner. And ultimately, the proceeding was closed and it was concluded that the petitioner has not been able to give any evidence in his support. And it was also recorded that this implied that the petitioner has accepted the charges. The final conclusion also referred to a number of documents by stating that the presenting officer had produced certain documents by way of evidence. This court is of the considered view that the respondents were duty bound to provide the documents which they were relying upon and were shown to be enclosure to the charge sheet. Those documents having not been provided to the petitioner, or their legible copy having not been provided, the petitioner has been deprived of taking due defense in departmental proceeding. In the judgment passed by the Honorable Supreme Court, in the case of Kashinath Dikshit, it has been held in paragraph 10 that in case of non-supply of documents and where prejudice is shown by virtue on account of non-supply of documents, that amounts to prejudice to the government. Paragraph 10 of the aforesaid judgment is quoted as under. This court has no doubt that non-supply of documents to the petitioner has caused, which were annexed along with the charge sheet, has caused grave prejudice to the petitioner. Consequently, the order of punishment cannot be sustained in the eyes of law solely on account of violation of principles of natural justice. In view of the judgment passed by the Honorable Supreme Court reported in the citation 1997, Volume 8 SSC, B. Karunakar, ECIL versus B. Karunakar. In the judgment passed by the Honorable Supreme Court in the case of ECIL versus B. Karunakar, the Honorable Supreme Court has held that if the departmental proceeding is set aside is interfered on ground of violation of principles of natural justice, then the departmental proceeding will resume from the stage from where there has been an error. In view of this fact, the matter is directed to be placed before the किसके पास जाएगा ये matter? Respondent number 2.
Engineer in chief, respondent number 3 last.
Before the respondent number 3, who shall ensure supply of documents which were enclosed to the charge sheet issued to the petitioner, and also appoint an inquiry officer for the purposes of conclusion of the departmental inquiry. ठीक है?
Yes, sir.
The needful be done by the respondent number 3 within a period of 2 months from the date of receipt of a copy of this order. And since the charge sheet was issued way back in the year 2011, the departmental proceedings be concluded within a period of 6 months from the date of supply of documents to the petitioner. It is further observed that it will be open to the petitioner to file supplementary show cause upon receipt of the documents, and the petitioner is directed to cooperate with the departmental proceedings and shall not seek unnecessary adjournments. अब बी करुणाकर वाला जजमेंट नहीं लिख रहा है. It is further observed that the petitioner is being reinstated only for the purposes of conduct of the departmental proceeding and no more. The state petition is accordingly disposed of.
For final disposal of this case, item 2, Civil Division 28 of 2014, and that is 3 and 4.
I think I was wrong yesterday when I mentioned. It is now Mr. Sudipto Sarkar, because of the confusion, had to take the afternoon flight which is delayed. He's on his way, but it is just planning. There are a few applications for substitution.
Pending.
The substitute as a notice can be accepted by Mr. Pati's office. He was appearing his instructions to account. So it is otherwise ready for hearing.
Otherwise, so substitution have to be formally allowed.
Formally
So
allowed.
he has entered appearance by filing वकालतनामा.
No, they are ready and they will file.
Received the वकालतनामा.
They have received it.
तो उसको पॉकेट में क्यों रखिएगा?
नहीं, allow करना पड़ेगा substitution. अभी कर देंगे.
You will file it during the course of
Yes.
this?
Yes.
IA number?
In Civil Division 28 minutes, it is IA number 409 of 2025. In Civil Review number 32, the IA is minutes.
Just a one by one. This is IA number 409.
Yes, madam.
This is for substitution of
So respond number 13.
respondent number 13. Who are the legal hearers? They have already been substituted in
In the trial court, they have been substituted. Now they have been substituted here.
18.3. The partition suit is pending.
Partition.
This is order
711.
711.
Rejection of
Then how the partition suit is pending?
it has not been rejected.
Okay.
The claim was the order. The application was rejected. The claim was not rejected.
The
Sir, I
application
assist
was.
the plaintiff before the trial court.
Yeah, just-
For number 1 year.
Just a moment. Let us complete the this substitution first. This is defendant number 13 has expired, right? What are the legal years? Who are
Was
the
set
legal
out in
years?
paragraph 3 minutes of this application.
Okay. देखिए IA number 409 of 25. The learned counsel for the parties are present. This petition has been filed seeking substitution of respondent number
13 minutes.
respondent number 13 or defendant number 13.
But both.
Both same. Respondent number 13, namely Aruna Devi Chaudhary, who is said to have expired on 7/11/2023. The details of legal years and successors have been mentioned in paragraph 3 of the interrogatory application. It is submitted that she has already been substituted before the learned court.
Trial court on 18.
Learned trial court on
18/3. 18/3/2024. By an order dated 18/3/2024.
14/3.
18 minutes. 18. We have annexed the order. It is 18th of.
It is 14/3.
अच्छा एक जगह 18 लिखा हुआ है, एक जगह 13 लिखा हुआ है.
By the order of the court, learned trial court, as annexed to the interrogatory
Yes.
application. Mr. Namataya,
Akshay Kumar.
Akshay Kumar submits that he has received, he is already in possession of wakalatnama and he has no objection so far as the prayer for substitution is concerned. He is otherwise ready to argue this case today. Considering the submissions, IA number 409 of 2025 is hereby allowed. Counsel for the petitioner is directed to delete the name of respondent number 13 from the cause title and insert the name of legal heirs and successors whose details have been mentioned in paragraph 3 of the interrogatory application. In red ink, During the course of the day?
Yes, we'll do it right now. We have given a compilation, so
That's right, during the course of the day. Let the wakalatnama be filed. We also file during the course of the day.
similar
So ready
IA
करा
is
के लेके आइए.
हाँ?
Ready करा के लेके आइए. Yes, similar IA in.
Similar means IA number 800 of 2025 and civil division 32
Just a moment. 800
of 2025
2025.
kept at flag O.
No, in civil division number
32 of 2014
number 32 of 2014.
and minus the other IA is 400.
Again, respondent number 3.
Respond 13, same.
Sorry, respondent number 13.
13
Same
para
order.
three,
Just
same order.
same order in civil division number 32 of 2014. IA number is 800 of 2025. You have received wakalatnama? Same order.
And
With
this last is minus civil division 14. The same IA is IA 408 of 2025.
Civil division number
14 of 2015.
14 of 15. IA number
408 of 2025.
408 of 2025. And same respondent number 13. Respondent number 13.
Respond number 13. Yes, ma'am.
But I think for some company,
ठीक है, same order. चलिए. All the three are arising out of the same suit.
Yes, the same suit, same order we are is under challenge.
Why 3 civil division?
Three defendants had filed 3 applications under 711. All 3 have been dismissed, so all 3 are the petitions before your lordships. So
Now
I'll just take your lordship through the matter till Mr. Sudipta Sharma is on his way.
one only the plaint.
Yes, it's
only
plain.
the-
Yes, ma'am.
Let us see the plaint
Yes, ma'am.
and then the order.
Yes, certainly. There is a compilation which we had given, Mr. Sir. नहीं, नीचे और compilation. Just so now there are three volumes. Volume 1 contains all the essential documents as far as disposal of 711 is concerned. Volume 2 contains the pleadings of 711 and the written notes which cannot for the present.
Volume number is not mentioned. Yes, volume 2.
Volume 2 is
And this is
supporting.
volume 1.
Volume 1 is the main volume.
And 1 doesn't have any
No,
index of authorities.
that is the judgment compilation.
Those are judgments.
Judgment compilation.
You have this short point here.
Yes, we have given the short points, different minutes.
There is one short point like this.
Yes, we have given notes.
Let us see the plate.
Yes. Kindly come to that minutes, volume 1. It is at page 1. This is 150. Now, just before, there is one plaintiff, Jitendra Kumar Agarwal. He has arrayed his dependent number. We also want to see the genealogy first, then that.
No, I just want to see the outlines. And what was the objection?
Objection is this. He says that this is a joint family property of Panwari Lal Agarwal. This one, I am representing Rahul Brothers. He said that there is a joint Hindu family. There is 1/9 share. There are 5 brothers, 4 sisters. 1/9 share is fine. He seeks a partition. In his plaint, he says that in 1982 there was some document executed, but the document is a sham, and the document was only for partial, for tiny bit portion, but it was for some tax purposes. He acknowledges it. And despite that, he claims a partition. Our case is that 1982 there has been a complete partition. 1981 there has been a complete. Yes.
So therefore, this is a matter of trial.
It's not as we have seen. That's why it's not a matter of trial. Once there is a document which is filed along with the plate, that also has to be considered with the plate for the purpose of 7. That is.
So let us see. Let
Yes.
us see where is his statement regarding.
Yes, para 27.
Just a moment. Let us see his relief.
Yes, and he just seeks partition. That is 50 words. It starts from page 49, page 50 of the compilation. For partition of 1/9 share of the plaintiff in the properties mentioned in schedule so and so, so and so, so and so for allotment of separate and exclusive management.
Let me see para 27.
Yes, that's fine. Page 30.
Yes.
That in fact there never was a registered deed of partition in 81, 82 or at any time in any form. Partition was never acted upon and it was just a pretension. Only a portion of B.L. Agarwala and Sons HUF was affected for income tax, and in view of the fallen health of the aged mother, Srimati Yashodi Devi Agarwal, BLA HUF was only 1 out of 6 HUF in the family and constituted a very tiny fraction of the total joint family assets. But P.K. Agarwala with T.K. Agarwala, who was always his yes man, forced all the brothers and the mother to sign a memorandum, and whenever a debate, dispute or demand arose about equitable partition in the subsequent years, they started waving, that was spelling is wrong, waving that document in the face of others to silence it. Kindly mark these three lines that we will be asked. Now it's 28. That an effective binding registered partition as per requirement of Partition Act was never taken place statutorily despite repeated requests of the plaintiff before the P.K. Agarwala and later T.K. Agarwala. It's now again, Manoj, kindly come to page para 30 now. Yeah. Para 30. That it would be mentioned here that the unity of possession over.
Para 29.
Para 29 also is not signed. That the plaintiff submits that late G.L. Agarwal, father of the plaintiff, out of his fund and joint family income, from the joint family business acquired properties like that of Gujarat Mansion, 1420 Street, Kolkata, flat number 18, 23, 24, within Kohinoor building at 105 Park Street, 16 Rajatrodamal Road, Delhi, consisting of 2 flats, each having 1600 square feet. On the ground floor and first floor, 2 flats in Basantpur, 1 flat in Saket Vihar, and in the capital city Delhi, Charia House in Kolkata, and other properties were also acquired. These properties, among others, have been mentioned in Schedule K. That it should be mentioned here that the unity of possession over all those properties have been established and admitted time and again. Although a different look was projected in the shape of Memorandum of Understanding in the year 1982, it was introduced as a so-called business stratagem. The contents of the Memorandum of Understanding cannot partake the form of a partition deed, which has some basic and essential requirement, including, kindly note, its registration under the mandatory provisions of Registration Act, being compulsory registrable. Besides, it covers only a tiny portion of the entire family assets. That Sri Parmeshwar Agarwal, as a shrewd politician as well as a seasoned businessman, knew how to rule and how to serve his own purpose. Only a few litigated assets, encumbrance properties, sick and non-profiting concerns were earmarked for the plaintiff with a huge liability too. That on the other hand, he himself earmarked the creamy assets, profitable companies and no liabilities. He also pleased the next 2 brothers Devendra and Mahendra Agarwal with some juicy tidbits to exercise divide and rule policy. He was the sole witness to all the signatories reflects his domination. After all, Parmeshwar Kumar Agarwal would become member of Rajya Sabha due to his political connections and plenty of affluence which he siphoned off from family fund and or family trading companies and other joint family properties, depriving other members of the family. He rose to the top and others felt ignored, particularly the plaintiff. No one could dare to raise any objection against the intrigues of the selfish Parmeshwar Kumar Agarwal, political elevator. That the said Memorandum of Understanding dated now kindly note 2 being confined to a small portion of family assets of B.L. Agarwal and Sons HUF, just 1 out of 6 HUF, was a gauzy document and was not signed by all the members of the joint family. Only the 5 brothers and their mother had to sign, and that too only when they said only it was given to understand that the deed of partition will be executed, and when actual partition will take place, despotism of Parmeshwar Agarwal banished from all forms, freedom of other brothers and other co-sharers, plaintiff was put in a claustrophobic corner. That memorandum of understanding was never acted upon, nothing was given to any of the signatories, the co-sharers. That the father of the plaintiff had also acquired properties in Nambad, which have been mentioned here under, as already stated. All such properties were purchased.
That's it. This is the crux.
This is the crux. So 2282 document is an admitted document filed along with the plate, and it has to be considered. Now before we proceed, kindly have a look at the document itself, which is at page 93 of the compilation.
who are the signatories to this document?
The plaintiff, all the 5 brothers and mother.
What about the sisters?
At that point of time, Lord, the amendment has come in 2005. So therefore, if a partition has effectively taken place, statutorily recognized, it can't be broken. That's the point which they are trying to make, but which will not help them.
We will not decide that.
No, correctly.
Not in order 7 ruling.
So it's not a question of deciding that point. It's a
It
question
is a
of
question of, because every member of the family is not a party to this particular deed.
they have not filed this suit.
Maybe they have not filed it.
That's the question. The plaint as it is, the lordship will have to decide whether it can stand or not stand. Whether it's barred by law, whether
You
there's a
see,
cause of
we
action or
will
not.
take whatever he has stated in his plaint as correct.
Absolutely.
He says that there is a memorandum, but it was never acted upon. That is his case,
Very
right?
Then
Once
he
it
says
is
it was
his
acted
case.
for tax
No,
purposes.
whatever it is. You see, he says that there was, you just have a look at the statement. We have just read it. This is the memorandum of understanding was never acted upon. Nothing was given to any of the signatories the proceedings.
Correct. Once the
So
lordship is-
therefore, merely entering into memorandum of agreement is of no use unless it is acted upon.
Correct, that is what he says. Now,
That is
kindly-
what he says, and that has to be taken as
in para
correct.
32, para
Yes.
27, kindly see para 27.
Even if there are some conflicting statements made, one paragraph.
Conflict. It's a question of his statement. Para
And
27.
therefore it has yet to be seen as to whether that particular memorandum of understanding
Yes,
was actually a memorandum
correct.
or it was itself giving some share to anybody.
100%.
If it was giving some share to anybody, then it is required to be registered.
Absolutely.
Otherwise, it may not be required to be registered.
Can I
So
just
there are
ask-
so many things, so many evidences has to come as to whether by virtue of that memorandum of understanding, two things. Firstly, whether that particular document itself is partitioning
Yes.
the property.
Yes.
The second is whether by virtue of that particular memorandum, actually the parties have actually separated
On.
or not. So this is a matter of
Really,
evidence.
It's not, respectfully, it will not. Your lordship will look into the document and see from the document itself. 2 things I wanted to point out before I go to the document. Mr. Sarkar is most kindly.
Yes, please. Please come.
My apologies for that.
No, it's no problem. There was some confusion, it appears.
Not only that, his flight also got delayed. I told his flight also overshot Ranchi runway, and now he's here.
So, leadership is perfectly right at the hearing election. But one of the point is, the Supreme Court has now said how the plain to be read in matters like this. Wait, as your leadership has observed, you have taken the plain as correct, but Supreme Court has in non judgment has said, how do you read the plain when you look at a matter? Kindly just consider that, then you know the leadership will read the plain with us. The leadership will read the plain with me after leadership will see the principle laid down by the Supreme Court. That's the
Prior
principle.
to that, firstly, I would like to see the principles laid down by the Honorable Supreme Court.
Yes,
In the light of that principle, we will read the plain.
that's right.
The second, and much prior to that, is the memorandum itself.
Yes. Now,
Let us
may I-
see,
may I
let us
point
have a
out-
just look at it.
May I- but the Supreme Court, that is why it's important. The memorandum below is mentioned. Then below the memorandum is part of the file with the leadership have to see the memorandum, number one. Number two, he is raising some contention about the memorandum. He said it's not registered, not that, but then it's a 1982 memorandum. It's still standing as a valid document. There's no challenge to the memorandum. Now, if that happens, if there's no challenge on any ground, then if a plaintiff has disclosed a memorandum and not challenged it for
Need not
last,
challenge it because according to him it required registration, it's of no use.
so then that's a point of law. No,
It's not a
no,
point
that's
of law.
it is very important.
Therefore, you see, for a partition through meets and bounds, orally, let us see that there is a partition orally done between the parties. 4 persons, one has got one house each. They have ultimately acted upon that. They have got their independent mutation done in connection with each of the property. And ultimately, in order to ensure that there is no future conflict in connection with this property, they can put it in writing that this has already been done, it has already been taken care of. Now we are just putting it in writing. This is called a memorandum of partition,
Yes,
and it does not require registration.
that is what has happened.
Let us see what
That
is the nature of the
you should
document.
give me a chance to show it to you.
Uh,
That
I
is
want
what
to
has
see the
happened.
memorandum.
No, that is what has happened here. Actually, leadership will take the memorandum.
I want to see the memorandum first.
Sorry. Leadership
kindly take the memorandum also.
93.
Page 93, begins at 93. Now, in addition, you will see who are the parties. Kindly come to page 95. This is important. And plaintiff is item number 6. Number 6 is page 95. Jitendra Kumar Agarwal, son of Banwarilal Agarwal, he is claiming a HUF of Banwarilal Agarwal here. In representative capacity, this is very important. As Karta of his smaller Hindu undivided family, consisting of himself, his wife, and one sons. All brothers have entered into the memorandum as Karta of their individual undivided family, broken off from the larger undivided of Banwarilal Agarwal, the 6 branches. Now, leadership will take page 96. Second paragraph. That's the old family. Parties here to the first part, second part so constituted a Hindu joint family governed by Mitakshara Sansa and Banwarilal Agarwal HUF. That's the old one. Then, whereas members mutually decided to effect partition of the family properties, and the members of the family agreeing there to decide on total partition of the family, and accordingly effects the total partition on 30th December 1981. Now this memorandum made between so and so, this is to record that fact of such partition effected on 30th December 1981. So this records the fact of partition made orally on 30th December 1981, and then see clause number 1, page 97. On 30th December 1981, the members of the said so and so Karta effected a complete partition of all the properties. Now, what is important, I'll show you leadership is this. His signature is admitted. It doesn't dispute.
Can you read it further?
Yeah. Partition of movable property including so and so, but in Annex Schedule A, then 3 is commercial asset, HUF being hardcore oven. It goes on, all the assets are recorded here. It goes on, and then kindly see page 98, clause 5. Clause 4 and 5. 4 immovable property. The property is belonging to page 98, divided so and so, Schedule C. He's got some property, which I'll show. He dealt with that property on his own capacity, clause 5.
By actually dividing the same in future.
No.
Yes,
Kindly
page
see
number
kindly
98.
clause 4. See clause 4. Just see one clause. Immovable properties belonging to family were divided. Past tense in the manner shown in Schedule C.
Kindly read the paragraph just above that.
Paragraph?
It has been further agreed.
Said hardcore of divided equally one to each among the parties mentioned. Was already divided.
Kindly read it. Kindly read the entire
Yes.
passage. It has been further agreed.
That the said hardcore ovens were divided equally, i.e. 1/5 share each among the parties mentioned in above, with all the right to own, possess and enjoy the same by actually dividing the same in future, if possible by selling. So those are not done. So therefore, then in that case, the plaintiff has to tell your ladyship that in this memorandum, this was not partition, this is partition. I can understand that case.
So therefore, even as per this memorandum, the entire property is not partitioned.
Because some of them could not be partitioned. But if the plaintiff is claiming partition of the whole, which they claim, then in that case, you have to challenge this document. I'm not saying that he can't claim partition of the whole, then the document has to go.
Need not.
No, I show the plane. That's why I'm showing you leadership. That's what I said. Let us look at the document. Leadership want to see the document. I'm showing the document. I'll come back to the plane, then leadership will examine the principles by how to read that plane. And look at. Let us see. Look at immovable properties, clause 4. Immovable properties belonging to the family were divided between the members and manner shown. So Schedule C. Schedule C is given because he's got a schedule also. Then 5. Several members of the family named above who are parties to the memorandum declare that they have no further claim on any portion of the erstwhile family properties allotted to members, schedules A, B, and C. He signed this document, and leadership will find his schedule. If you kindly see at page 100, subclause F, these properties are indicated there, which has gone to him. property allotted to Jitendra Kumar Agarwala being the party's own 6 parts were enjoyed by smaller Hindu joint family so and so mentioned in Schedule I. And Schedule I, leadership find also, he signed this document. 111.
What
What?
about 7?
I'm sorry?
What about 7? It's
That's a
not,
future liability.
it's not. Just,
After.
can you read it?
After partition, all liabilities, refunds, reclaimed, etc., and actions after partition shall be borne and be shared equally by the parties here to second, third, fourth, fifth. After partition, if any liability comes to the firm,
Also the refunds also.
yes, of course. I'm not saying no.
So if there is 2 property and there is a refund in connection with 1 property, it will be shared equally.
The point is depends on who gets that property. See, if it's already partitioned, see
It is
what
already-
clause 7 deals with.
If there are 2 industries,
Yes,
it goes to A and B, 2 brothers.
yes.
If normally the partition takes place, then under such circumstances, any refund or any liability attached to that property goes to that particular person, isn't it?
Yes.
But clause 7 says that in case of any refund or any liability, the refund as well as liability will be shared equally amongst all.
Because it is what has happened actually after the partition. If something,
Certainly,
see, what
there
has
could be a
happened-
liability.
Ladies,
There could be a liability
may I-
on
may I
a
just point out
particular
what happened,
property.
ladies? See, a claim of refund will arise earlier, but will fructify after the partition. But if it has arisen earlier, and it is matured later on after the partition, then parties will have to share. That is what it says. Because partition is there's a guillotine, there's a date. So on that date, the liabilities are ascertained. So if some liability has arisen or a claim has arisen before that date, then that date has to be adjusted. And that is why what I want to show you, leadership.
Arising or accruing after partition.
That's right, after the partition. So after the partition, no, accruing in the sense that it will arising or accruing after partition means it has suddenly come up now because it's between one year now. But what is important, leadership will see, if assuming for a moment, the plaintiff is running a case of partial partition, which is said at one place, then the plaintiff has to fail. Because if he's claiming whole partition, then he's challenged this document. The document, assuming he is right, there's partial partition. Then unless he challenges, the document is set aside, he cannot get the whole partition. There is no cause of action, the limitation point will arise in that case. Now, what is important is the partition recognized by income tax is all here in the document, in the plate, income tax and wealth tax as complete.
So according to the plaint, he claims that it is partial partition.
No, he does not say that. You see, what he has said is, when challenged with some, may I show you right arrow, page 111, kindly take page 1, schedule I. Plain, he says nothing about partial partition. Kindly come to schedule I, page 111. Now take the asset, take item number 1. Building at Haribandi Road, Hirapur, Dhanbad. Now, he has sold this property as his own individual property and realized the entire consideration money. Now he said that. Now when confronted with this, he says, oh no, that partition was partial. Plainly does not say that. Because Supreme Court has said the normal course, I give you the leadership, that if required under Order 10, you please call the plaintiff and examining to ascertain, get some clarity. So he was called. There was a subsequent order. Initially, Order 10 application was rejected because this was heard without Order 10. Subsequently, Order 10 order was passed. Plaintiff was examined. Plaintiff was confronted with this sale. He admits the sale and says, yes, that's correct, but that document created partial partition. Now, let you take that into account now. As I say, I'm just pointing out, I'll read the plain to leadership. I'm only concerned about the 1982 document and what the plaintiff says about it. And what is the plaintiff's claim? If leadership takes the claim claim of the plaintiff in the plain. Kindly see that. Prayers begin at page 49, paragraph 48. See, Supreme Court merely says in leadership that court should examine whether it's an abuse of process or not. Page 49, because I can understand all courts will have a reluctance to reject plaint at the initial stage, naturally, because plaintiff has come to court. You have page 49, paragraph 48. Plaintiff following relief. Now see the relief. For partition of 1/9 share of the plaintiff, the property is mentioned in schedule C, D, so and so, allotment, so and so, plaintiff. All, and that property then court receiver, those are all consequential prayers. The main prayer for partition is prayer 1 at page 50. Whole partition. Now what is the property he wants partition? Look at the nucleus is mentioning. Kindly come to page 10. 56. Yes, schedule B. Page 56. You give the details here, schedule B. These are schedules, see all properties. And his case is, leadership kindly comes to page 11 once. Page 10, I'm sorry. Page 10 is part of paragraph 4. He's talking about what is the issue of property. Kindly come to the bottom of the page, last few lines. The basic companies, business concerns which flourished during the regime, and 49 to 69 Banwarila died. So that 69 is important. Are mentioned in Schedule B, meaning thereby the Schedule B formed the corpus, and Banwarila and his brothers created the NCR Action during so and so. All the property is subject matter of this partition suit. Very important. Have one and only nucleus, Schedule B, from which they have originated so and so, so and so. Where the case of partial partition is. He is claiming entire Schedule B, whatever Schedule B was there from 47 to 69, entire property is getting partitioned by various schedules beginning from Schedule B. Schedule B is the original schedule, and then what will follow up the nucleus growth is from Schedule C on. So, leadership have to see the plain that you study. I cannot improve the plain, I can only comment upon it. The leadership can't change the plain either. So now, if your leadership keeps this in mind, I'll come kindly now see paragraph 27. What is said about the document at all? Paragraph 27, page 30. That in fact there never was a registered deed of partition in 1981, 82 or any form. Partition was never acted upon or was just a pretension. Only a portion of B.A. Lagawala and sons were affected for income tax and in view of fallen health aged mother, so and so. Only 1 or 6 HA in the family considered a very tiny fraction of the total joint family assets. D.K. Agarwal always yes man, forced all the brothers and mother to sign a memorandum. Whenever a debate, dispute, demand arose by equivalent partition, they started waiving the document in the faith of others to silence and it is sent. Effective 28, effective bind registered partition. Now, if this is the plaintiff's case, then unless he challenges that document on whatever ground, his case should have to fail. Because the prayer is for the whole partition without a challenge. And I'll show you, leadership, Supreme Court is very clear. If a document is outstanding against you, which you have signed, and you want to say that it is not valid or binding, then you must challenge that document. Because he admits signature of that document. And this partial partition and income tax, he admits the document. He says it was there, it was pretension for income tax, wealth tax. But in that case, he has to say this document is not binding on him. Because he is himself saying that, the document was waiving the document in the face of others. So, others were relying on this document, some of the defendants. The others are relying on the document and he wants to say the document is not binding. Then the Supreme Court judgments are very clear that you have to challenge the document for cancellation if you are a party. If you're not a party, then for declaration. You cannot have the document outstanding and bypass the document and make out the case. If you want to challenge the document, suit was filed in 2013 or 2014. Challenge would have been barred by limitation. It's a 1982 document. Hence, that's why it's not done there. So, that is the reason why this is the plane. Supreme Court says, please examine the plane for the substance and see what it's all about. And I'll show the judgment that you have to ask for a cancellation if you want to challenge the document. Otherwise, the document, you are bound by the document. It's a document signed by him. It's not a legal matter. It's a factual matter which was raised. No point of law is involved. There are two. Now, impugned judgment does not deal with this question at all.
Where is your petition?
My petition, volume 2.
And you were citing those judgments. Please cite those
Before I
judgments.
do that,
Volume 2.
yeah, the leadership kindly see the two income tax return.
And no,
I'm
just
sorry.
one more thing. The female members of the group, they also filed petition under order 7.
No. They were not.
They have not.
No, the lady members had no title to this property before 2005.
We will see that. But they are not aggrieved by the partition suit. In a partition suit, all are at equal footing, isn't it?
No, they are not agreed because the partition took place in 1981. They had no interest in that.
No, they do not say that they will relinquish or they need not be party here or nothing.
I don't know
But
what
yes, they are not opposing the partition in any manner.
I believe they filed 2 statements saying they have no claim. 4 of them. 2 of them.
But still, that is a matter of written statement. They can give up the entire property. There is no problem about it. They must be pretty well doing well.
Leadership is examining the plaintiff's claim for under order 711. As your leadership has correctly said that written statement is not to illustrate at this stage. You are not looking at my case. You are looking at the plaintiff's case. So my submission leadership is how should the claim be read in such a situation is one question. Secondly, he mentioned registration, whether in law registration was required is second question. And third question is what sort of case he made out to sustain the prayer he had made in the play at page 50.
So let me just take down your 3 concerns. One is that he has not challenged the memorandum.
That's not challenging.
Seeking any relief against that.
No relief. He mentioned that it was waived at him, he is not binding.
That's right.
But he has to claim.
Second, plaint has to be read as a whole, along with the documents.
He has filed all these documents anyway.
He has not made out a claim for a case of partial partition.
May I just point out what I was trying to claim? If he claims whole partition, the document has to be challenged. If he wants to make out against a partial partition, he must bifurcate that asset to say this has gone under the memorandum. This is what remains. You please partition this.
He claims no partition.
He claimed.
Technically, he claims no partition,
partition.
because he says that it was never acted
That's
upon.
right. I'll come to the acted upon point.
Yes.
Now, may I just briefly show the acted upon point? Leadership will take the tax returns after the memorandum was filed.
That is also a part of the plaint.
He referred in the plate.
We will not see. If he has not annexed it, we will not see it.
He has not annexed it. The statutory order, he has not annexed it, but he said it was for the purpose of tax
We will
purpose.
not see any document. If he has not annexed it, we will not see.
I will deal with this point. I'll come back to that point. No, leadership first, we don't know. Leadership will kindly see in order 17. Kindly see, may I just show 1 or 2 judgments, then it will be clear what I am submitting. First take that point I said, which is 1977, about how a plane should be read.
Compilation. It's page 16.
But we kindly take 1977 volume 4 Supreme Court cases, page 467. That's leadership. I believe in
This is on the
compilation.
point how the plaint is to be read.
Yes, how the plane has to be read. In an order 7, rule 11 application. In your leadership and the index to your compilation.
Yes, I'm looking at that.
But the first one is item number 2, which I am showing on leadership.
Yes.
Others have followed that judgment. I am just showing the principle, just
Yes.
Krishna I laid down.
That's
Kindly come to your leadership compilation, paragraph is at page 19, paragraph 5.
yes. Yes, please.
We have got the slightest hesitation in condemning the petitioner for the gross abuse of process of the court repeatedly and independently resolved it. But the statement of facts found in the judgment of the High Court is perfectly plain. Suit now pending before the First Municipal Court, Bangalore, they flagrant misuse the mercies of the law in receiving claims. The learned municipal person, this is important, must remember that if on a meaningful, not formal reading of the plaint manifestly vexatious and meritless, in the sense of not disclosing a clear right to sue, he should exercise power of the orders of the level, taking due care to see the ground mentioned that is fulfilled. The clever drafting has created the illusion of a cause of action. Nip it in the bud at the first hearing by examining the party searchingly under order 10 CPC. An activist judge is answered irresponsible lawsuit. The trial court insists imperatively on examining the party at the first hearing so that bogus litigation can be shot down at the earlier stage, meanwhile also successful and so on. So this is a principle which has been followed up to I think 2024, if I'm not mistaken.
That's
And if Lordship leadership would see, it's castiging the bar, I don't know.
no problem. It's okay.
Paragraph-
This
paragraph
is
one-
so clear and clear a judgment.
No, I'm on the
It means-
principle. I'm on the principle, not on the facts of the case. I'm on the principle as to how a claim should be read. And
That's
that will be followed. I would trouble leadership with the cases, item number 3, 4, they are all followed.
That's right. So
I-
the principle, the golden principle is in serial number 2.
Yes. And order 10
And
examination.
you were also showing some judgment which says that the documents are also to be read.
Yes, yes.
Which is that judgment?
No,
That is not in compiled separately.
no. May I before I do that, I need leadership to look at item number 5. This is important. 2002 10 Supreme Court cases 501. That's very important. Leadership will see what the Supreme Court has done. Follow that principle laid down in the earlier case. Page 64.
This judgment?
No, that is the next.
We'll see that.
No, I'll come there. I can't.
First this judgment.
Can you take this 2002 10 SCC 501?
Yes. Which paragraph are you reading?
Now, here Lordship will see, follow the paragraph 2, that old 97 case is followed.
Yes.
And leadership to see what is important is, kindly see the pleading was, the pleading is mentioned in paragraph 3. Then, now leadership will see, after that, kindly see what paragraph, from paragraph 4 onwards. After reading those paragraphs, the Supreme Court observes this. Significant to note that the transfer of portion of the property in the year 1941 has not been challenged or disputed in any way. On the contrary, it has been averred in a para 9, second area, 6 bigas so and so, this so and so was sold without an authority and contrary recycling the said sale is illegal, that is not binding on the plaintiff. This is a pleading. Now the additional district judge, however, is considered to say we come to the conclusion because with the knowledge of the plaintiff such sale will take place, the plaintiff has taken this step, the matter having documents say it is invalid, not binding, effective, too late to contend the same at this stage. This is very important. The document is sharing in the face. Then, on the factual score, it further appears, being agreed by the order passed so-and-so, plaintiff in the suit moved the High Court by appeal and the High Court upon so-and-so, set aside the order, hence the special leave petition. While the suit only issued, then kindness is 7. As noticed above, the learned singular of the Allahabad High Court, though elaborately laid down the requirement of Order 711, the true effect thereof, in our view, totally misstated and misapplied the provision of contextual facts. No explanation whatsoever available in the plain as to situation under which suit was filed after a long period of 40 years. Knowledge of the deed of sale stand accepted by the reading of the above in para 9. On an analysis of the plain, apart from there being a mere bald statement, the sale deed had nothing to do with the rest of the area, so and so, with stand to be so and so, so and so. There is no other advertisement in Title 6. Admittedly, so therefore we have to look at other documents also. Which one? Yes. Wait. Yes. Now, therefore, it's not available in the play. As you can kindly now see, admittedly, several portions of the plots were demarcated. So they dispute as regards 3 bigas, as regards so environmental plane itself. Plane is totally silent on this score. This is very important. If the plaintiff is silent, leadership need to see it. Why is it silent? If there is a case, don't know how it exists, it can accept it. The view cannot be termed utterly vexation and so on. And document part, leadership will see what will be. Yes, kindly see page 79, that is part of, start at page 68. That is very recent Supreme Court judgment. 2024 SCC online, SC 384. Now this has been law for a very long time. So you give it para 12 at page 79. And is settled in law para 12. The application is rejected being filed above it. I'm sorry.
Yes. Yes, please.
Page 79, paragraph 12. Now, reject the plain is filed above in the plain document annexed therewith Shona or German. Above Shona can take it down only to consider. The documents form part of the plain. And the case we have given to your leadership. Leadership will take the case I have given you leadership. 2020, 7 SCC 366.
That's right. These are all settled principles.
These are all, it's very clear. Then if you are trying to bypass a document that's not binding or effective or whatever, then you have to, if you have signed the document, you must challenge for cancellation. And there is the trial judge's judgment says limited question of mixed factor law. There is no mixed factor law here. The document is admitted that it was executed by him. He is arguing on something on the document. One is non-registration, one is not acted upon, and the third one he said that it does not, it's only deal for income tax purposes, not complete. When the document says complete and effective partition.
How do you actually prove that it was acted
How
upon?
do
In
I-
a case of general partition, what is the method to prove
Yes.
that the partition
Because
was acted upon? Merely because there is a memorandum, is it sufficient?
No, no.
Or there has to be some act of the parties to show that actually it was acted upon.
That is right. Leadership will find. So far as our group is concerned, the defendants were all enjoying our own individual properties. So as the plaintiff is concerned, I showed you leadership immovable property in Schedule I. I'll show his statement under Order 10 where he's admitted that I've sold, which is that page. Kindly take the last page of the part of the court record. Please kindly take that page. Do I need to show anything more? Because I am challenging the plaintiffs. Kindly come to page 263.
A person can also sell undivided portion also.
No, yeah, you can see page 263. When you
Page
see
number?
page 263, statement in court under Order 10,
263.
volume 1. Volume. Look at, you should got it page last, I think last page.
Last page.
I think it's in Hindi,
When was it recorded?
but I couldn't English something.
Hindi is at 259, the English translation is at 2.
On me, I can't read Hindi very well. See,
Please read it.
but translation
We
is
are
page
actually
263.
there paragraph 4, which is at page
3 and 4, 3 and 4.
Paragraph 3 and 4.
3 and 4.
Yes, read 3 and 4.
See, I am not saying,
I'm
he
just
says it's not a partition deed. We are not saying it's a partition deed. We are saying partition, because orally, memorandum records it. Now, kindly see what document is only your signature of his brother, not have any sister, not relevant in 1982. Only for income tax. Therefore, the income tax return, it is we have to see. What does income tax and wealth tax say?
Assessment orders.
The assessment order, he is referring to it. He himself is relying on that for the purpose of showing what the document
But he
was
has
for.
not accompanied it along with the suit. He has not filed it along with the suit. Things which he has not filed along with the suit, we will not
Now,
look into
this
that.
is
It
what
could be.
This is what 2002 says. If a plaintiff deliberately suppresses a document,
It is not a
sponsor
matter of
of a case.
suppression. You see, it is not a matter of suppression.
No.
He has made a statement. Suppose he has made statement about 10 documents, but he has filed only 3 of them. So what we will see is the plaint and only 3 of them.
But
Either if you can demonstrate on the basis of the plaint itself that it is absolutely proof that he acted upon it, the matter ends.
no, I just
Then we'll see. Then we'll call upon the respondents to respond.
no.
I'm still not
May
satisfied
I
with your
just, may I
case.
just
So,
I would expect your leadership to reject the plaint just like that. I'm not expecting it should not be done also. That's not my argument. Look at paragraph 4 at 263.
kindly read that Hindi
Hindi,
portion.
paragraph 4. ये बात
3 and 4.
3 and 4. दिनांक 2/2/1982 में दस्तावेज पर मेरे हस्ताक्षर था, परंतु ये दस्तावेज बंटवारा नामा नहीं था। ये दस्तावेज में सिर्फ हम भाइयों का हस्ताक्षर था, किसी बहन का हस्ताक्षर नहीं था, और ये दस्तावेज सिर्फ इनकम टैक्स के लिए था। 4. ये बात सही है कि सेल डीड नंबर 4459 दिनांक 1/8/2001 मैंने लिखा था और उक्त संपत्ति दिनांक 31/12/81 के बंटवारे में प्राप्त कर संपूर्ण मालिक के रूप में विक्रय कर रहे थे, परंतु ये बंटवारा सिर्फ कुछ संपत्ति का था। This is not the same detail of page 166. So he has admitted the document. 166 minutes he says that. Kindly look at 166 minutes. This was shown to me.
The document was shown to you.
This sale deed has been exhibited.
Not exhibited. It was
Then-
shown under order 10,
Order
which
10.
is permissible.
Now you want to rely on it.
Yes, sir. He is admitted.
He says that. No.
We will not see the sale deed.
No,
He has
this-
said so, but that is all.
But order 10, what happens is, order 10 there's an examination. Order 10 rule 10(2).
That's right.
So there's an examination before the trial begins, and the court, this was put to him,
That's right.
which he is admitted. Therefore,
When was the petition rejected? Order 7 Rule 11.
before the order 10.
So before that it was already rejected. So what is this order 10 examination must be prior to.
Should have
Should
been
have
done.
been.
That is what we are
No,
arguing.
no.
That's right, but this has been done later.
Yes.
Yes.
So how do we acknowledge this?
No. Legitimate kindly see the order. Improved order says that I don't have to wait for order 10. I'm challenging that also. The order has to set aside on that ground alone in my submission. Supreme Court said you please examine, if you find you need to examine order 10. Impeach order said I don't have to examine order 10, it's rejected. We made a prayer, please adjourn, do the order 10. She didn't do it. But he didn't do it. No. See, leadership will kindly now see. Principles are clear. It's our endeavor to satisfy our leadership on the plane that it's an abuse of process, it's a meritless. Now, point is, leadership wanted to know whether it was, forget the sale deed. He has said only for income tax, so he admits the documents for income tax. So for income tax, there will be complete partition. The document talks about complete partition which he has disclosed. And therefore, that's why income tax, which is, he says, he admits the document, it creates for income tax. Income tax shows complete partition, the document says complete partition. Short point, ultimately, leadership boils down to this. Can the plaintiff go on with the suit without challenging the 1982 document? On any ground? In some form. He said, kindly now see, paragraph 4 said partition only for a few property, partial partition. So there was a partition.
We are in civil revision jurisdiction. Let us see the impugned order.
Important.
It must be in this comparison.
Yes.
Liquid submission,
Kindly.
page 422, 226.
Kindly, Mr. Sinha.
Yes. 226.
Yes. प्रस्तुतवाद आज
You
आदेश
just come to the point.
सॉरी
प्रतिवादी के विद्वान अभियोग.
पेज 226 में
Yes, at the bottom.
नो
the
कैन
findings
वी
are-
जस्ट अलाउ अस टू रीड मिनट्स हाँ प्रतिवादी के विद्वान अधिवक्ता का ये कथन है कि इस बात
Wherever-
में
Yes. You just read from where you want. And I want to see the petition that you had filed.
that is in volume 2. Volume 2 has all the 711 petitions. Volume 2 mirrors has the
They are identical.
more or less identical. There are 1, 2, 3 are the applications. Then there is a common replies 4. Then the written notes filed by the plaintiff. Then the written notes filed by the
Just show
defendants.
me one petition.
Petition was first petition is by the defendant Jitendra Kumar.
Page
Agarwal.
number.
Page 26, volume 2, the first document, page 264.
260.
Starts at page 264. The first
Okay.
document.
This first document. There is another memorandum of understanding on 9th of July. This is memorandum of understanding is dated.
This is one of the 2nd of February 1982.
There is another memorandum on 9th of January 2012.
No, that is between a few of the parties.
We do not know it is mentioned in your.
Yes, that is one we can explain. That's not a part of the plain, but that is otherwise
That is irrelevant.
irrelevant.
That is just
because
a
we are now
narration.
not confining on it. 2012 or 72 or 1990.
Okay, very good. Yes,
The order minutes. Kindly allow me to read the first 2 paragraphs as well. That is
Yes.
important.
read it.
प्रस्तुत वाद आज आदेश हेतु नियत है। प्रतिवादी संख्या 1 के द्वारा आवेदन पिछली तिथि दिनांक 25/6/14 को ये कहते हुए दाखिल की गई की गई थी कि उनके आवेदन को आदेश 7 नियम 11 का निष्पादन अभी रोक कर रखा जाए तथा उसे उचित समय यानी आदेश 10 नियम 1 के तहत सुनवाई के समय निष्पादन किया। यहाँ ये उल्लेख करना आवश्यक है कि इस वाद में 3 प्रतिवादियों के द्वारा आदेश 7 नियम 11 के तहत विभिन्न आवेदन दाखिल किए गए हैं और तथा उनके विद्वान अभियुक्तगण और वादी तथा प्रतिवादी संख्या 3 जो वादी के वाद का समर्थन करते हैं के विद्वान अधिवक्तागण सुना। अतः अब ऐसी परिस्थिति में प्रतिवादी संख्या 1 के द्वारा दिए गए ये आवेदन कि उनके द्वारा दाखिल आदेश 7 नियम 11 के निष्पादन को रोक रखा जाए का कोई औचित्य नहीं है, वो भी वैसी अवस्था में जब तीनों प्रतिवादीगण की ओर से सभी समान बिंदुओं पर बहस किया गया है। अतः प्रतिवादी में इस आवेदन को खारिज किया जाता है। दैट वाज रिजेक्टेड। इस वाद में दाखिल आदेश 7 नियम 11 के 3 आवेदन जो प्रतिवादीगण
the adjournment was rejected or this examination was rejected?
No, the adjournment. We had said that please don't pass
The
an order.
adjournment was
Rejected. So we had made a request. इस वाद में मैं दाखिल आदेश 7 नियम 11 में 3 आवेदन जो प्रतिवादीगण संख्या 1, 7 और 8 के द्वारा दाखिल किया गया जिसका प्रत्युत्तर वादी एवं प्रतिवादी संख्या 3 की ओर से भी दाखिल किया गया है पर विचार किया जा रहा है। प्रतिवादी संख्या 1, 7 और 8 की ओर से मूल रूप से निम्नलिखित बिंदुओं ही उठाए हुए आवेदन दाखिल किया गया है कि वादी को वाद दाखिल करने हेतु कोई वाद हेतु प्राप्त नहीं है तथा वादी ने चतुर्पूर्वक वाद प्रारूपण पर भ्रम पैदा करते हुए वाद हेतु तैयार किया। वादी के द्वारा किया गया दावा व अनुतोष का मूल्यांकन कम किया गया है। वादी मांग किए गए अनुतोष समुचित न्याय शुल्क दाखिल नहीं किया है। वादी के द्वारा दाखिल किया गया वाद परिसीमन विधि के प्रावधानों के अनुसार कालबाधित है। वादी द्वारा दाखिल किया गया सेवी एक्ट 92, कंपनी एक्ट 56, बिहार एंड उड़ीसा कोऑपरेटिव एक्ट तथा ट्रस्ट एक्ट के विभिन्न प्रावधानों से बाधित है। वादी द्वारा दाखिल वाद इसलिए भी पोषणीय नहीं है कि वादी ने अपने वाद पत्र में इस तथ्य को स्वीकारा है कि वादी और प्रतिवादीगण के बीच पूर्व में बंटवारा हो चुका है। वादी द्वारा दाखिल वाद पत्र में ऐसी संपत्तियों का उल्लेख है जिसका बंटवारा असंभव है। वादी द्वारा महत्वपूर्ण तथ्यों तथा यथा पूर्व बंटवारा तथा सभी संपत्तियों के कारण विवरण नहीं दिया गया है, ये दिया जाना तथा आवश्यक पक्षकारों को पक्षकार नहीं बनाए जाने के कारण ये वाद खारिज किए जाने योग्य है। विद्वान अधिवक्तागण को सुना। That is with respect to not including the companies of which partition has been sought and the cooperative societies and other things. प्रतिवादी के विद्वान अधिवक्तागण का ये कथन है कि इस वाद में वादी को किसी प्रकार का कोई वाद हेतु प्राप्त नहीं है चूंकि वादी ने अपने विभिन्न पूर्व के कथनों में इस तथ्य को स्वीकारा है कि वादी एवं प्रतिवादीगण के बीच पूर्व में बंटवारा हो चुका है। इस बिंदु पर विद्वान अधिवक्ता का ये कथन है कि वादी ने अपने वाद पत्र में इस तथ्य को स्वीकारा है कि वादी एवं प्रतिवादी के बीच में बंटवारा हो चुका है और इस हेतु मेमोरेंडम ऑफ अंडरस्टैंडिंग सभी पक्षों के बीच बना है जिसमें वादी ने अपने दस्तखत किए हैं पूर्व में सन 1982 में इस तरह से।
These are all the arguments advanced.
Yes.
The
The findings are at perhaps page 229. अब अभिलेख का अवलोकन नेक्स्ट पैराग्राफ सेकंड पैराग्राफ। अभिलेख का अवलोकन किया एवं उभय पक्षों को सुनने के उपरांत ये पाता हूँ कि इस वाद में वादी द्वारा प्रतिवादीगण के विरुद्ध ये वाद संपत्ति के बंटवारा के लिए दाखिल किया है। जहाँ तक वादी का ये कथन है कि ये वाद परिसीमा के नियमों से बाधित है, इस बिंदु पर मैं पाता हूँ कि वादी द्वारा अपने वाद पत्र में कथन किया गया है कि वाद संपत्ति संयुक्त पारिवारिक संपत्ति को लेकर पहले कई पारिवारिक व्यवस्था फैमिली अरेंजमेंट किया है। अतः किसी खास फैमिली अरेंजमेंट एमओयू को लेकर पारिवारिक व्यवस्था को लेकर परिसीमा की अवधि तय करना उचित जान नहीं पड़ता है। इस वाद में परिसीमा की अवधि को तय करना विधि और तथ्यों का मिश्रित प्रश्न है जिसका निष्पादन उभय पक्षों के साक्ष्यों के आधार पर ही किया जा सकता है। जहाँ तक प्रतिवादी का ये कथन है कि इस वाद में बहुत से तथ्य को छुपाया गया है तो प्रतिवादी इन तथ्यों के इस स्तर पर नहीं उठा सकते हैं क्योंकि इस स्तर पर केवल वादी के वाद पत्र एवं उनके वाद पत्र में संलग्न कागजातों को देखा जाएगा। जहाँ तक प्रतिवादी का ये कथन है कि वादी को वाद हेतु प्राप्त नहीं है, इस बिंदु पर मैं ये पाता हूँ कि वादी के वाद पत्र के अवलोकन से ये स्पष्ट होता है कि वादी ने वाद पत्र के वाद संपत्ति पर अपने हिस्से को अलग करने हेतु आवेदन दाखिल किया है। अतः ऐसी परिस्थिति में ये कहना कि वादी को कोई वाद हेतु प्राप्त नहीं है उचित नहीं जान पड़ता है, क्योंकि प्रतिवादीगण कहीं से ये नहीं कह सकते कि वादी उनके परिवार के सदस्य नहीं है अथवा वादी को वाद संपत्ति पर कोई हक नहीं है। जहाँ तक प्रतिवादीगण के द्वारा किया गया कथन कि वाद विभिन्न प्रकार से बाधित विधियों से बाधित है, इस बिंदु पर वादी के विद्वान अधिवक्ता का ये तर्क है कि वादी वाद संपत्ति में अंकित कंपनियों, ट्रस्ट, कोऑपरेटिव सोसाइटी इत्यादि कर लाभों पर अपना हिस्सा मांगा है, ना कि उन संपत्तियों को विखंडन, अंतरण अथवा अन्य रूप से निष्पादन हेतु। अतः ये वाद ना तो ट्रस्ट एक्ट, बिहार एंड उड़ीसा कोऑपरेटिव सोसाइटी एक्ट अथवा किसी अन्य विधि से बाधित है। जहाँ तक परिवार में हुए पूर्व बंटवारा का प्रश्न उठाया गया है, इस बिंदु पर मैं ये पाता हूँ कि उभय पक्षों के बीच में विभिन्न वर्षों में पारिवारिक व्यवस्था और एमओयू की बात कही गई है और सभी कागजात अनुबंधित है, जैसा कि उभय पक्षों की ओर से स्वीकार किया गया है। अतः ऐसी परिस्थिति में ये कहना कि किस एमओयू अथवा पारिवारिक व्यवस्था के अंतर्गत उभय पक्षों के बीच पूर्ण रूप से बंटवारा हो गया है, इस स्तर पर अवधारित करना असंभव है। उपयुक्त विवेचना अनुसार मैं ये पाता हूँ कि तीनों प्रतिवादीगण के द्वारा दाखिल आवेदन कोई बल नहीं है, तदनुसार उपयुक्त तीनों का आवेदन खारिज किया।
That's all.
Because we want to see submissions filed by them.
What submissions?
The written submissions filed by the plaintiff in support of his Order 7 Rule 11 objection. 2 paragraphs. Because this is a part of the record of the 7 11. Kindly take notes this page 339 of volume 2.
Volume 2. Even at this stage, we will not see what they have submitted. We will primarily see what is the claim.
That's correct. This is a part of the in writing. They
Even if in writing, if they have stated something, we will not take into consideration by considering a case regarding Order 7.
This is a part of the proceeding
It
under
is-
711.
That's right. Even if a person says something, it does not form a part of it.
So what he
of the
has said,
suit.
what he just merely
Maybe
explained.
whatever he has said it is irrelevant. We will only see the claim, the document,
We will only-
the impugned order. That's it.
It will only give us clarity in just looking at what the plaintiff has been thinking and what he knows. Just have a look, let's be 339. Because he can't dispute this.
Of first volume.
Second volume. And this is a part of the record, hence we are not denying it.
You see, if we take that into consideration, then that particular stand which has been taken by him in his reply will be treated as a part of the plaintiff.
No, what he says, no, it isn't written, so what he says. He says that what your lordship has been asking. Kindly just allow us to see para 7 of his written statement, 339.
Written statement.
Written submission, written notes. He
Written submission is also not on affidavit. What do you mean written submission?
This is what is filed by
Written
him.
submission does not form a part of the record at all.
But he says,
Written submission, please don't ask us to do this.
it is suppose
Written submission does not form part of the record in any manner.
Submissions we file before your lordships also.
No, that
is
does not form a part of the record. It is not on affidavit.
It only says that yes, the family
It
arrangement
is
was abided
not
by.
on affidavit. We will not take into consideration. It does not form a part of the suit record, and I am absolutely averse to written submission. Taking, we are facing that situation. When we ask somebody to file written submission, they say many things which is not there in the record at all. And those, you won't believe, those matters are also mentioned in the written submissions which are not even argued in the court.
That's correct. But here is something which is
No,
which
no,
he says that
please,
I was
that
not
we
abided
will
by
not-
it.
No, I will not.
But this
I
is
am
something-
absolutely very, very clear on this. If you want a pronouncement on this, I will give a
No,
pronouncement.
we
on
don't
this.
want a pronouncement at that point, but we are only saying that it was only said that it was abided by.
No, we will not take into consideration. That does not form a part of the record in any manner.
Because there was a question which was followed from your last week, or they have also taken this objection that now the trial has proceeded.
No, it can come at any stage now
That-
that
that-
is there.
the
That
debate-
judgment you have shown
Shown.
that it can be decided at any stage.
Yeah.
Plain shall be rejected, then power under can be exercised by the court at any stage of the
Correct. That is what it says also.
The sisters are supporting or opposing?
Sister.
Sisters are here before us.
Some of them are there.
Some of them is
No, all
of
of
them
them,
must
all
be
of
there.
them, all of them, all of them.
Where have they gone? They have disappeared.
Mr. Abdul, I'm sisters. Mr. Pati is there. Sapir is there.
Okay, you are here. Whom are you representing?
He is the
The
plaintiff.
plaintiff, so respondent number 1. And my senior advocate, Mr. Iman Bhattacharya, has appeared online and will
Okay.
assist you also.
And one more thing, what do you say to the females' right?
Females, right?
Females are not party to that partition. Please explain.
The date of the original HUF was 1969.
Okay.
Plaintiff is claiming his right from 1969.
Okay.
Whatever property is acquired is a 69 right. Now they should examine whether the daughters had the right on that date or not. Because the right crystallized on the death of Banwari Lal. HUF was created on 69.
You see, if the property continues to be joint,
Yes.
then under such circumstances, if the partition takes place today, let's take a different situation. If any partition takes place today, she has a right, irrespective of the fact as to when the ancestor died.
Point leadership is examining is what was the position in 1982. The
Provided-
my argument is contention out of 1982, not what is happening today. Because the partition took place in 1981, recorded in 1982, then the matter is over. The ladies had no right on that. Therefore, I mean, I can understand if the partition had not taken place, then they'll acquire a right. So naturally, they'll be interested in that sense. But ladies should not consider that. The plaint is about what happened in 1982 or did not happen in 1982. That is
Yes.
the argument.
Respondent to that.
My senior. That's why.
Good.
We just have wish to make one more point first, which your lordships are saying that we cannot make is that 171 income tax. The reason is he himself says
171
income tax. That's important because 171 income tax is an assessment order. In his plaint, he says
assessment order. Whose assessment order?
the HUF after resolution which records that there has been a complete partition affirmed by all members, including him. So if he has suppressed that statutory order, why it is important is to answer your lordship's question of the women. If it is for statutorily recognized prior to the 2005 amendment, then it can't be reopened after the amendment. That's the law. The issue which your lordship is raising has to be answered and looked into from that point of view.
So therefore, if the income tax order records that
Yeah.
there has been a complete
Yes,
partition,
yes,
that's the end of it.
yes, because the section says so. The statute says so. It's a finding given in terms of section 171 of the income tax, which after. Sorry.
Let us see where is that finding of
Yes. Kindly take that.
Where is that order of that?
Yes.
That is not a part of the plan.
If he suppresses, we can't help. Therefore,
No.
section. Kindly have a look at the section.
No, maybe the section.
But
But
twice.
the point is that this is something which you have not argued also before. The
Yes,
court.
we have argued.
On the basis of this.
Yes,
Did you file this income
Yes,
tax
before the
return?
trial court. Yes, because I can show it from the petition. The trial court has not said anything on that. The
No.
point is, whether an admitted document, a document of unimpeachable character
You
can
say
be looked into.
document of unimpeachable character produced by the defendant also will not be taken.
We are trying to say, Rajdharan said.
Rather the judgment which you say, the document which is annexed with the plaint, and if that document is of unimpeachable character, that will be
No,
taken.
all documents filed with the plaintiff will have to be seen. The point is, if a plaintiff comes to court, suppresses material facts, and Rajanarayan says, yes, if it is vexatious, how will your lordships come to a conclusion it is vexatious? Because then I am not showing anything which requires proof. I am showing a document which is passed by statutory authority in exercise of powers under the statute. How can that be ignored? And my lords, it is not
So that is binding on the court.
on the party. The point is, it's binding on the plaintiff. It's not the court, it's binding on the plaintiff. It is his duty to disclose facts, material facts. If he suppresses, but then what happens is, anyone comes, gives half-baked facts and says, no, now the matter has to go on for trial. Kindly appreciate it from our point of view. 81, the partition takes place, families separate. Now he does not do well in his own business. Now he says, give me a share. How do we deal with it? This is a frivolous litigation. Ultimately, it will not go anywhere. We are already suffering for 10 years. Just have a look at section 171 and the document. He says, if your lordship may not take it for the guy, but for our matter, just have a look at the document. Where he appears and affirms that yes, there is a complete partition. and document just.
But it is not even your case that there has been complete partition.
Yes, it is my case, my lords. I have always been saying it's a complete partition.
But
He
his
says-
case is that it was not complete in any manner.
That is what I'm saying, that the only fact is that if the order records that there has been complete partition of HUF. Now one more document, he does not dispute 82, kindly take page notes. This is we missed it, but just have a look at the 82 document for a moment. Yes, that's true. I'll just kindly come to volume 1, page 97 for a moment, which is a part of the 82 document. This is undisputed, this is filed along with the claim.
Page?
Page 97, running page.
Yes.
That on 30/12, now this document is dated by 2/82. That on 30/12/81, the members of the said erstwhile Hindu joint family. So in February 82, all parties are referring to the Hindu joint family as erstwhile joint Hindu family. Again, the same word is used at the bottom of the page, the erstwhile HUF. If all parties agree that the HUF is now erstwhile, it is no more in existence, can in 2013 they seek partition of that HUF? When immediately after a month you said it's become erstwhile, it's not there. Now this fact, my lord, is also supported by a statutory order, which the Evidence Act says that your lordships can take judicial notice of, because it is passed by a statutory authority in due exercise of his powers. Now the document which the kindly come to note is that page 113. In fact, the order is at page 117 and 16. If your lordship comes to page 116 for a moment. Lordships have come to page 116. Why with an application dated 2nd August 1982, the Karta of the HUF style Banwari Lagar claimed that there has been complete partition of the assets and
Who is the
liabilities.
Karta?
Huh?
Who is the Karta?
The earlier Karta was Parmeshwar Agarwal. I'll read it, just allow me to complete this, will make it very clear. There has been complete partition of the assets and liabilities among the members of the HUF, namely Yashwati Devi Agarwal, widow of late Banwari Agarwal, Parmeshwar Kumar Agarwal, son of late Banwari Agarwal, Sri Devendra Kumar Agarwal, son of so and so, representing his smaller HUF, Mahendra Kumar Agarwal, 5 is Devendra Kumar Agarwal, and 6, Jitendra Kumar Agarwal, son of Banwari, representing his smaller HUF. Notices of inquiry were accordingly issued to the erstwhile members, of the HUF. Each member has affirmed to the fact of partition. Statement on oath by Sri Parmeshwar Kumar Agarwal has also been recorded. The statement is placed in WT folder of AY so and so. The deposition has been testified by all the members. On partition of the members have received assets and liabilities as detailed in schedules under. So received by meets and bounds. Jitendra Agarwal Schedule I. The description of the properties have been made in the above noted schedule annexed with the memorandum of partition filed along with the application on 282, a copy of which is enclosed. As per the memorandum of partition dated 282, the complete partition has been effected on 30/12/81. The claim of partition has been gone into. The claim is in order. Complete partition of the assets and liabilities has affirmed by each of the members is allowed. So, and this method is being sought to be overcome, undone by the suit. Because he says, he knows that there is an order under the tax, and therefore he says that this was only for a taxation purpose, not only in para 27, but also in under his statement under order 10. So this can't be ignored. Similar order was passed under the Wealth Tax Act, page 133. Now let's just section 171 subsection 2 of the Income Tax Act says an inquiry, after making an inquiry,
Where is wealth tax?
wealth tax, 133, no? It starts at 130, but the order is at 133, same, similar order.
For 183.
Yes. Here also says the complete partition allowed from 3/12/81, not 2/2/82. 3, that is the date of oral partition. 171.2 is only attracted when there is complete partition, not otherwise. So a finding has to be recorded that it has been complete partition. This I think Mr. Sarkar
This
just
is
forwarded
section.
this submission. Sorry, no.
This is section.
This is 171 of the income taxes. 171 subsection 2 says the inquiry will record a complete partition.
Well, the relevance of this point, Milord, is this. Under 171, if an order is passed, the issue have to examine whether or not the claim of partition is barred by law or not. That is the point involved. It's a legal provision. It's not a question of fact. So you have to examine that he said it was done for the purpose of income tax. Income tax purpose order we have produced may not be on part of the plate. But if a point of law arises that we say the plate is barred by law, then you have to examine whether it be limitation any other statutory bar or Supreme Court judgment that is to be examined by the question of law. Is it barred by law or not? And once the income tax 171 order comes in, it is no longer possible for him. He was a party to that. He recorded that he was there, he was heard, inquiry was carried out. Now, if he bypasses all statutory provisions and files a suit, are your leadership's hand tied completely? Just because plaintiff filed a suit and that will go on for harassing everyone else in the family.
That's all. You are here.
Milord, I represent the plaintiff,
Yes.
who's respondent number 1 in this application.
Yeah.
Quite a lot of my points of arguments have perhaps been addressed by your lordship in the questions being put, Milord, to Mr. Sinha and Mr. Jharkhand. But Milord, one thing that I like to point is, let's assume for a moment, Milord, that this 1981 deed, this memorandum of understanding, was not something which was not to be given effect. Let's assume that is to be true for a moment, that this was to be given effect. Well, kindly just turn to the documents one. The document starts, my lord, at page 93 of the compilation.
Yes.
And then kindly, my lord, come to page 97.
It's 97.
My lord, 97. I'm reading, my lord, further. Kindly now come to 98. I'm sorry. 98, the first paragraph.
Yes.
It had been further agreed that the said hard core ovens were divided equally, that is 1/5 share each, amongst the parties mentioned above, with all the right to own, possess and enjoy the same. By actually dividing the same in future, kindly mark in future, if possible, by selling, letting and or commercially exploiting the same. But as the said hard core ovens are under tenancy of so and so, it was not possible to partition the same by means and bounds. So admittedly, there is at least one property which admittedly was not partitioned. So my suit can't be thrown out. Let's assume out of 100 properties in the schedule in my partition suit, if 99 I may have wrong. Even if there is one property which is yet to be partitioned, my plaint can't be rejected because it would then amount to a part rejection of a plaint. Now, my lord, kindly consider the schedule to the partition deed, and kindly come to, my lord, schedule I for India, at page 111.
Yes.
Kindly, my lord, see. Properties allotted to group of Shri Jitendra Kumar Agarwal, that is myself. Now, your lordship would see there, my lord, building at Hari Mandir Road. This has been sold as an HUF after this deed was executed. This was never sold by me as a vendor. So this property never actually came to me. There was nothing done to give effect to this partition. Likewise, the next entry, hardcore cover.
Just pause here for a moment. Just pause here for a moment. They say that you have sold it by referring to the partition deed.
No, but I wasn't the vendor.
You were not the vendor.
I was not the vendor. This has been sold as an HUF property. Now, my lord, kindly also, my lord, let me point out your lordship, the subsequent entries there.
Not a small
Hard
HUF, not the larger HUF.
Hardcore
I
Kavan,
showed you lordship, the
agricultural
partition
land,
was, my lord,
then my lord, 1,000 shares of Mechanical and Electrical Engineering Company Limited, 4 shares of so and so Coal Syndicate Private Limited, and then my lord, the Regional Labour Commissioner Dhanbad. My lord, let them show how these have come to me, because my contention is that these haven't been partitioned. I haven't got these assets. Whether I have got these assets or not, my lord, is subject matter of the suit, which will be decided in trial. So, admittedly, one property, as per the pleadings in the MOU itself, the contents of the MOU was not partitioned. In so far as these other properties are concerned, which were to come to me, not a word have they produced, my lord, to show that these have come to me. And hypothetically, assuming that they even produce those documents, that will be subject matter of trial, because my lord, the Order 7 Rule 11 has to be based on my plaint. Where I've contended that these are nothing of this has been partitioned. This MOU was a sham. So,
Their
my lord,
contention is that you have not challenged this MOU.
I'm coming to that now. Well, I understand the argument is that somebody in Dhanbad has been a shoddy draftsman, and therefore I should be deprived of 334 crores of my inheritance, assuming it will be 1 night. And if the sisters relinquish their share, it will be much higher. Well, just for a prayer not being inserted, well, for my entire case to be thrown out is an absurd proposition. And I'll tell your lordship why. Let's assume, my lord, that I don't challenge this. Even then, the partition has to be effected in the worst case, at least in terms of this document, so that I get what is stated in this document. If there is an MOU, this is not a deed of partition. It is a memorandum of understanding to give effect to some sort of a partition. Now, if the MOU hasn't, let's assume that it's a genuine document, but it hasn't been acted upon, then if I lose in my suit, in the worst case, I'll be entitled to partition in terms of this MOU. And then they'll have to give me Schedule I and also partition the property which as per the MOU itself is not partitioned. So I'm taking my case at the worst. Let's assume that this MOU is valid. It has to at least be given effect to. So in the trial, if it so appears that this MOU was a sham, which probably will, then in that case the partition happens as per my schedule. If it so appears that the MOU was valid, if the MOU was genuine, then the court will go into whether this MOU has been given effect to or not, which is again a subject matter of trial. And if the court finds that this MOU hasn't been given effect to, which I am contending, then at the very least, in terms of this MOU, I am entitled to the properties which are mentioned here. So this case can't be run in a Order 7 Rule 11. Whether I challenge or I don't challenge is inconsequential. The fact is that there are properties which are still jointly owned and which have to be
Whatever
partitioned.
remains is required to be partitioned.
So maybe my yes. So my non-challenge to this MOU may perhaps linger in my case longer. I may struggle to get a preliminary decree because there will be other things to prove. It may not be a straightforward case. Yet my plaint can't be thrown out. Just because a draftsman in Dhanbad doesn't put in a prayer means I lose out on my entire family ancestral wealth to the tune of 334 crores, conservative estimate. Then, my lord, kindly now consider that this, my lord, partition, again, I am again proceeding on the assumption that this partition is valid.
Why are you abusing an advocate in Dhanbad? If it was so valuable property, he could have got it drafted in Kolkata.
No, because I have had.
Don't abuse advocates, right?
No, I will tell you.
There could be a reason for not challenging it. We don't know.
No. I will tell you, Lordship, why. But I have had only one single opportunity of interacting with the plaintiff, and the plaintiff confessed to have drafted it on his own. Which is why, my lord, I am not restrained in my criticism of, my lord, the language used in the plaint. Nonetheless, my lord, what is there. I have to deal with the plaint as it stands. I can't, my lord, improve upon it in this proceeding. But nonetheless, now, my lord, kindly also consider that the schedule which is in the plaint, which I claim is the large family estate which hasn't been partitioned, vis-a-vis the schedule in this MOU, my lord, there is a vast difference. The properties in the schedule comprise almost 10 to 12% of the total properties mentioned in the plaint. So even if assuming hypothetically that these have been partitioned and have been given effect to, even then, my lord, majority of the estate is yet to be partitioned as per my
Much is remaining to be partitioned.
Remaining to be as per my own plaint. because HUF as an entity can hold.
Then what do you
property.
say? Then what do you say to that income tax order?
I'll come to that. Right? But HUF, let's assume that I am the patriarch of the family and I have a wife and 2 children, and with the 4 of them I form an HUF. And then the HUF acquires, say, property A, property B, property C. But separately, in my individual capacity as an individual person, I may acquire 20 other properties. So upon my demise, those 20 properties also then would devolve upon my surviving widow and my children. So just because HUF properties have been partitioned doesn't mean that the rest of the estate also stands partitioned. So what they are showing the MOU, that only pertains to the HUF in the name of my deceased father. But what I show in the plaint is the entire estate. Beyond what was there in the HUF. The HUF is just a subset of the entire estate of my deceased father.
Anything
So
else?
that will be evident from comparing the schedule in this MOU to the schedule in the plaint. Now for a moment, kindly now consider that there is another, and why there is another deed of 1999. Kindly see that deed. It is at page 140. 140.
Is it
Yes,
a part of the
139.
plaint? Is it a part of the plaint?
Yes, my lord, it's a part of the plaint.
139.
I have pleaded so, my lord. May I first please the pleading, my lord? Kindly see the pleading, my lord, in paragraph 39, at page 40 of the plaint.
Yes.
So just before I show this, even if as per the IT, even if assuming that as per the IT entry was correct and the entire partition has been given effect to, even then there are majority of the estate is yet to be partitioned, because at IT was only to do with the HUF, and the phrase erstwhile HUF also is confined to the HUF. This doesn't prove in any way that there are that there can't be other properties beyond the HUF which was part of the family estate and of which I am a co-passer. Now, my lord, kindly now consider page 40. And I am completely in agreement with both Mr. Sharkar. In fact, my lord, is the president of my bar, and Mr. Sinha is also, my lord, somebody whom I highly regard, my lord. He's been my senior in a few matters. I agree, my lord, that the plaint ought to have been written in a better, and there's no denying that. Kindly take paragraph 39. That the plaintiff is your ladyship there?
Yes, I'm
Yes. That the plaintiff never knew as to when he was silently but surely sidelined from the family. There was no such deed or document or any notice or information by or from the other brother or brothers or sharer that the plaintiff is being separated or going to be separated. But a clandestine memorandum of separation signed by only 4 brothers, alleged to have been prepared on 26th day of May 1999, stating unceremoniously that the plaintiff Jitendra Kumar Agarwal has separated himself from the joint family business and family trading companies. For what earthly reason one will relinquish and give up his interest and separate himself from the huge, of course it's a rhetorical draft, my lord, kindly pardon me for that, give up his interest and separate himself from the huge business emperorship of his father, running in hundreds of crores, and start his own business remains unexplained in the said profane memorandum. The plaintiff has been victimized inexorably. His mother consoled him, so on and so forth. So now kindly now consider this 1999 settlement. If it is so indeed that the 5 brothers and the mother had a full and final separation in 1981, then why in 1999 would there be another settlement, a family settlement, keeping me out without me being a party to it? Kindly consider page 139. This is, my lord, the memorandum of the 26th of May 1999 at page 139. And, my lord, kindly see the parties between Parmeshwar Kumar Agarwala. He is, my lord, my eldest brother. Also, my lord, kindly remember that when my father died, I was in my teens. And the age gap between the eldest brother, who's the only opposing defendant in this partition suit, and myself, the youngest brother, is nearly 20 years. 18 years, I believe. I beg your pardon. So I was in my teens, and I was for the longest time at the mercy of my eldest brother, who then took over as the patriarch upon the demise of my father. And that is how the to be done. And in the course of that, there are a lot of things which transpired in my early 20s, late teens, which I am not even privy to. So I perhaps can't think of an explanation of some of the things. They may certainly come up with anything in the trial. This is another impediment that I am facing, practically speaking. Kindly now, my lord, consider this 1999 deed. It's between the eldest brother and the other 3 older brothers. So 4 of my brothers, keeping me away, execute a deed amongst themselves. And kindly then come to page 141.
They are describing themselves as their smaller HUF.
Exactly. Which is why, my lord, this is to show that this HUF partition, even if I take, there are cases that the HUF was fully partitioned. Even if I assume that the HUF was fully partitioned, there remain lots and lots which was to be partitioned which hasn't been partitioned. And I will show how. Kindly see page 141. And whereas, kindly see the second whereas recital on page 141, which refers to my name, Jitendra Kumar Agarwal. And whereas the said Jitendra Kumar Agarwala have been separated from the parties here too and doing independent business and have no connection with the parties here too. But how, on what basis, on the basis of which document do they get this? If they get this finding from the 1981 settlement, then this should equally apply to all the parties to that settlement. But out of the 5 brothers, 4 brothers are doing a further partition.
No, they are not doing a further partition. This is not a
Of course.
partition deed. This
No,
is
but
just a
because-
memorandum in connection with some of the properties that Schedule A, B, and C. Each one of them, they are describing themselves to be a separate HUF.
No, and then, my lord, and then,
And merely
Yeah, but
because it has been
then-
mentioned that you have been separated, that takes you nowhere.
and whereas parties here too have also separated between themselves and have their own HUF and are separately, and whereas the first party is in exclusive control and management of BLA Industries, second party so and so, third party so and so, and whereas parties here to family members, other nominees hold distinctive equity shares in the various companies specified in Schedule A, B, C, D hereunder, and whereas for the purpose to ensure complete separation between the parties, you kindly see, Malad, kindly see the line. So they do refer to some instance of there being some separation, but they acknowledge the fact that there has not been a complete separation. And this is not even a document to which I am a party. So why am I being left out? This is just to indicate possibilities in the trial.
This is
Would you
another
understand?
memorandum that
I'm-
the partition had taken place. This is what
Malad,
they may say at best.
to have my claim thrown out at this stage, I'm assuming the case to be the worst against me, admitting for the sake of argument all their submissions. Even then, my lord, there are instances to indicate that I have a triable case. That is all I have to show.
That's it. So, your best case is that there are, in the memorandum also, there was something yet to be partitioned. And then
This is
you
my
want to
worst
say
case.
that, that's right, we are not going to give a finding as to what is to be partitioned. But the point is, your case is that in the memorandum also, it was not a complete partition, there was something more to be partitioned. And secondly, your case is that the schedule to the suit does not tally with the schedule to the properties mentioned in the memorandum.
Not just that, it is much, much wider. The schedule in the
That's
plaint is majority of the estate, and what is shown in the 81 agreement is a minuscule subset of that schedule.
That's right. That
Which
should be
I
sufficient.
have included in the plain schedule, because even that hasn't been given effect.
That's right.
MOU hasn't been acted upon.
That's right.
They haven't put anything on record to show.
So your
that the agreement was acted upon.
contention is, even if that MOU is not set aside, so whatever be the partition with respect to the properties left, that is required to be partitioned.
Yes.
There
And
will be
if the MOU,
the partition.
if the MOU is not given if the MOU, they say that the MOU is not being challenged. Even if the MOU is not being challenged, the question still remains whether it's being given effect to. Because MOU doesn't create a partition. MOU fathoms a
This
partition.
is what they are showing, that you also filed your affidavit before the income tax authorities by saying that MOU has been duly effected and there has been complete partition. You filed your affidavit also before the income tax department and ultimately before the wealth tax department also, and it was duly acknowledged and accepted by those authorities.
So, Bharat, which is aligned with my plaintiff's case, that I would listen to the oldest brother. He was a father figure to me once my father passed away, because I lost my father when I was in my teens.
That's
And at which point in time the eldest brother was in his 30s. I may have signed a lot of things, but the fact is that what I was to get under that MOU has never come to me. Let them show one document as to how the MOU was given
What
effect
was
to.
your age in 1983?
In 1983, I was 29. 29.
Yes.
Because these are patriarchal families. Here, one man calls the shots, and there is a very rigid hierarchy even amongst brothers.
That's
These
I
are
did see
families
that.
where a younger brother
Let's-
touches the
Let's
elder
listen to
brother
the
before
sisters.
leaving
Yes,
for others.
sisters, what do you say? Are you supporting or opposing?
Yes, supporting and
Supporting.
Mr. Sinha and adopt what he actually addressed the issue that was raising. It's a pre-amendments partition, so that effect of amendment will not revive our share. We have already relinquished the partition.
All of you, all the sisters. How many sisters are there? And is there any sister who is not represented? Because I will record it.
I appear for 12 and 13.
No, you can't represent all the sisters. Where is there are 4 sisters?
I am okay move on to 14.
The respondent number
I am for 12 and 13.
14.
and 15. There is one more. 15 and 16. You have also filed your written statement. Don't be so silent.
No, he is not. He is. Mr. Atul Banerjee was appearing. I made a chart note for two of the companies. That is from the other side. So sister.
How many sisters are there?
4.
4 sisters,
4.
right? Who is representing whom? Tell
Well,
your tell the name of your client.
12 and 13.
12 and 13. Mr. Patti, right?
Yes. 13 has been substituted. I will
You have filed Wakalatnama on substitution, Mr. Patti. Are you sure? Have you taken instructions on this? No, that's right. But there is no affidavit as such.
No, the WS is there.
In the WS, you have given up your rights.
No, what we can do is produce the WS. That is the stand they can take maximum. Nothing beyond the WS. So we'll file a copy of the WS notes by Monday.
Respondent number 12 and 13 has given up the rights. Who else is there?
Mr. Sarkar is
There are other 2 sisters.
14 is
You are representing 14.
She's the daughter of one of the sisters.
I don't know.
From
This
the
is for you
sisters.
to ensure.
No, it is as per the plaintiff.
Yes.
for the
Daughter
party-
of one of the sisters, how does she become a party?
Plaintiff has made them a party. That's
And that sister is not party.
No, she's no more. I believe. She's no more. She's passed.
Who is representing her?
14 guy, Alka Devi is I think Mr. Sarkar.
Respondent number 14.
Defend number 14, respondent 14, Mr. Sarkar.
You have also given up the claim. There is one more.
Vibha Devi Mittal, that is.
Where is the 4th sister? So I'll simply record that you are supporting the.
I think one of them was not taking a stand. Neither here nor there. One of them. If I-
Maybe that written statement
Yes,
has not been
that's what I'm
filed. We do
saying.
not know.
That's what I'm saying. We have that.
So is any sister supporting Mr. Sinha? That's my.
All the sisters are
No,
supporting
there
Mr.
are
Sinha.
two.
Sisters are supporting Mr. Sinha.
Yes,
No, two are there. Two of them. 2 or 3.
3 of them. Three of the sisters are supporting Mr. Sinha in the open court. And these are all recorded proceedings. So I'm just
Would I-
learning them by and large and telling them.
Would I only know who are the sisters? Because
Yes,
this
I'll
has
tell
come
you.
as a
You
surprise
tell
to
the
me
name of the
suddenly.
sister.
No, they may be relinquishing their rights. To that extent, it's understandable.
That is
But
what.
that is
That is
support,
what.
Mr. Siva.
It
that
is
my
one
claim
thing
should be
to
rejected.
say to relinquish the right.
What
It is
more
another
is-
thing to say that they have nothing to do with this partition. Relinquishing means what? That
Ah.
relinquishing means that they have a right but they don't want a share.
No, they have said in the WS, if I'm not wrong, therefore I'm able to that we do not have any share in the property. That's
Do
what
not have any share or relinquishing the right are two
What?
different things
No, they
altogether.
have said that
I
I'm not
just
very
don't
sure. So we'll file the WS. I have not read the WS. As far as I remember, I think they said that we do not have any claim. They'll
Are
also
you
check.
sure that you are supporting the petition that the claim should be rejected?
Exactly. That's the question.
Well,
They
best
are
best-
instructed. We
best
don't bother about
best
it.
is not will file because no, they have neither
No,
filed.
we are not
separate-
going to look at
That's
what
what I was. They have neither filed.
they have been instructed to submit that they have to support your petition. The plaint ought to have been rejected, although they have not filed independent petition for rejection of claim. Correct? This is your stand. The third sister is not around. Where is she?
Because if I may request, this is not on instruction, I'm making a request. If there is any sister who is taking sides in the dispute between the brothers and is contending that my claim should be rejected and I should not be entitled to my share, kindly let that be put on affidavit by the sisters. Because this narrative is unbelievable as per my instructions. The sisters have always been neutral, they are successfully married, but they were never to as per my best knowledge, to take sides.
You won't make allegations.
You see
And
now at
and
this
let it
stage,
go on
after
affidavit.
hearing so much, we will not ask them to. We will just if the sisters are aggrieved by their submission, they will book them. We don't bother about it.
Wait.
If the council makes any submissions which is beyond their instructions, it is for them to take care of, and sisters will take care of it.
Allow them a day's time to take.
Why? What do you mean? I have heard you for 1.5 hours. I will not allow anything. I will not allow any further affidavit. What is this?
It's not a question.
No, you
What is
don't need to
the
bother about
point
them.
is, my lord, your lordship asked what
They
is
are
the-
all very senior advocates.
No,
we
that's
don't bother.
correct. What I am trying to say is, your lordship asked whether the sisters, or what Mr. Rachin
I just
Lakwan is saying.
wanted to know.
Yes, it's correct. But the sisters' stand is, as I said, they have separated. Therefore, they have no interest in the litigation. Kindly appreciate this. Now, they have not filed 711. They have not just been a spectator. They are a party. They are a party. They are not taking any sides. That's what I'm saying. But the WS also says is neutral. What we say, I think two are taking a side that we do not have a share, our shares of it. So their stand is irrelevant. The point is, it is my petition, and they have to defend it. That's the point.
So this stands clarified, Bharat, that the sisters are neutral, which is what is true.
That doesn't matter. But it hardly makes a difference.
That's all. Do you want to say anything more?
Well, I'll take
There's one more
very
sister
short.
is not there.
Very short.
One more sister. Whom are you representing, madam? Plaintiff. And you? Whom are you representing? You don't know.
No, Mr. Atanu Banerjee, some parties, they had filed Order 6 Rule 16 petition that our property should be deleted. Thereby, they became parties in the trial court. They were not original defendants. So they were made parties subsequently by their own volition that you are seeking a partition or partnership firm, I am the partnership firm.
Okay.
So therefore, they are also irrelevant for the purpose of
Very good. So they are irrelevant. Fourth
That's
sister is not represented.
Let's find out.
That's all.
Very brief, Worship, in the 5 minutes. I don't know my learned friend instruction. Look at the sale deed and you see the same color. What you said in the sale deed on paragraph I show you, Lordship, the recited.
You just respond to his argument that there was still more to be partitioned.
No, the same
Even
deed
as
was-
you forget about the same deed. Even as per the memorandum on face of it reveals that there was something more to be partitioned in future.
Kindly, my lord, pardon me, my lord.
This is
Kindly
what
look
he
at
has
paragraph.
submitted.
One
Second point he has submitted that the properties mentioned in the memorandum of partition does not tally with the schedule of the property mentioned in the plaint.
My lord, kindly take one page, 104. Kindly, my lord. No, 166, I'm sorry, 166. Kindly take that.
163.
Yes, kindly see, my lord, this, my lord, signed deed,
163 is a blank.
166.
166.
It's part of the sale deed, which he now admits he had executed. Look at what he said in the sale deed. But each page has been signed by him.
This is a part of the plaint?
The sale deed,
Is this a part of the plaint?
No, not part of the plaint. Order 10, it came out in order 10. The sale
But
deed.
that has not been exhibited as such.
No, sale deed produced.
No. Nothing.
Order
It has
10
not yet been exhibited.
Order 10 statement,
Statement is there, but sale deed has not been as such taken on record.
I don't know what kindly see the lordship decided page 166, look at the paragraph is it. Whereas after the death of the said Manohar Lagaval, his widow and sons amicably partitioned their properties by memorandum of partition dated so and so. And accordingly to as per the partition, widow bench's scheduled property came to the exclusive share of the vendor, since vendor had been in peaceful possession. So I'm only on the acting up point, If he says I'm not acting on it, how will it be established? Lord will examine whether he is acting or not acting on it. And the last page of this volume, he has mentioned about the sale deed, in his oral order 10 state. That's one. Second one, Lord should be see, there is one word is family, the other one is family property. What is important about the memorandum is memorandum about records, partition of the family itself, not only property. Look at the memorandum. So kindly see the memorandum begins at page 93. Partition the family has gone. Kindly see that, kindly see page 96, which he has signed. Admittedly, he was 30 odd years old on that day.
That's
Look at page 96.
yes, we have read almost the full text of the.
No, that's no. Kindly see second paragraph between the Hindu joint family, third paragraph. Forget the property now. A party of family and a member of the family agreeing they have to decide on the total party of the family. And then the properties come. So question of any more proper family remaining after that cannot arise. And that is what it mentions next page, page 97, clause 1. On 30th December 1981, members said erstwhile Hindu joint family of which so and so, every complete partition of all the properties by the family. So family goes without, there can't be any further partition. It's not a committee, it's not for us to say which property is going to be. It's a plaintiff to tell your lordship, ladyship, that these properties were partitioned, if not partitioned, if a suit came whole and if the deed remains it's barred by limitations. And the share, even the co-common rent is divided. The share, 99 I don't know why we're relying on it. 99 is do internal arrangement of control of companies. No assets were involved.
I'm grateful, Maharaj.
That's right. That should be sufficient. If we heard the learned counsel appealing on behalf of the parties. The arguments are concluded. You have given your written submissions, I have heard it. It's all recorded, so there is no problem. The problem is that I'm getting many things in written submissions which are not even argued in the court.
No, that should not be.
You see, and this is all recorded proceedings, so it is always available with me.
That is true, but then
No problem.
Give us a short date, we can file. Can you limit the pages,
One page.
We have given 4 pages.
You have already given 4 pages. You have already filed your written submissions. You want to add something, please do it. There is no.
Respond.
Okay. The learned counsel appealing on behalf of the respondent, other than the plaintiff,
have given the appeal.
other than the plaintiff, have submitted that they have nothing to say in the matter. It's safer for you, right? We have to take care of everything.
Okay.
They have nothing to say in the matter. The petition under Order 7, Rule 11 was filed by 3 brothers who are the petitioners before this court.
No. 2 are nephews of the plaintiff. Asim Agar are nephews of the plaintiff. One is
pastor,
brother.
one brother is pastor. His sons are.
By 3 brothers or their legal representative.
Yes.
That should suffice.
2
Or
brothers.
their legal representative.
2 brothers. Parmeshwar Agarwal's 2 sons are filed. 1, 2, and Devendra Kumar Agarwal is 1. So he's 1 brother and 2 nephews.
You see, either the brothers or
So
the
3 brothers nahi hoga. 2 brothers.
2 brothers and legal representative of third brother.
So, but one brother,
One brother and legal representative
of another brother.
How many brothers are there?
Five.
Five.
Plaintiff
Okay.
is J.K. Agarwal.
That's right.
Parameshwar Agarwal has passed away. His sons Asim Agarwal, Anup Agarwal are before your lordships. Now there is Devendra Kumar Agarwal who is also before your lordships. These three filed,
Just
7 left.
The learned counsel appearing on behalf of the sisters and their legal representative submit that they have nothing to say in the matter. Sufficient?
Sufficient. Yes, madam. Yes, that's correct.
The learned counsel appearing on behalf of the plaintiff respondent has submitted that on the face of the memorandum of partition, it indicated that there was further partition which was required to be done in future with respect to certain properties. He has also submitted that the schedule of the plaint does not tally with the schedule of the properties mentioned in the memorandum of partition, which was in the memorandum of partition. He submits that even if his worst case is taken into consideration without admitting the partition in the way back in the year 1982, then also there is much property which was required to be partitioned. This is a submission he has done. Arguments are concluded. The counsel for the petitioner has filed short written notes of argument. They submit that they will further file short notes on the basis of arguments which has been advanced during the court proceedings. They undertake to do the needful by Monday.
Tuesday.
By Tuesday. Please take care that whatever you have submitted. So, arguments are concluded. Post for judgment एक date दीजिए. इनका online लिखेंगे. Give your details. Mr. So and so appeared online. Give your details regarding appearance.
Yes, I believe my advocate on record is physically before.
Yes, of course he's there. You see, your client would see him. Maybe he will not be able to see you. Mr. Indranjeet Sinha was telling me one day in our video recording, the persons who are appearing online, their face is not being projected. So we have to do something that you are also projected in our recording.
No,
whatever it could be, our presence could be in question.
No, we are, you see, I am very particular about recording the appearance of the parties. The reason being that if anybody might question me that such and such counsel never appeared, how did you record his appearance? So we are very particular about it. So you don't need to worry about it. Give your appearance. 2 persons online.
Yes, please.
For the plaintiff. Pose this case for judgment on 12/3, just prior to holiday. There is one judgment to be pronounced. I think parties are waiting for the judgment.
That's on the 12th of March already.
12th of March. It will be listed for judgment and it will be pronounced.
Give your best.
Item 1, second appeal 493 of 2018 for judgment.
All the substantial questions of law are answered in favor of the appellant. The second appeal is accordingly allowed. The judgment passed by the first appellate court is set aside, and consequently the judgment of the trial court remains. This is what I have done. It will be uploaded maybe by tomorrow.